Welcome and thank you for attending. Questions can be asked using the questions pane in the webinar control panel. A copy of the handout can be found in the handout section. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to your presenter. You may begin.
Hello and good afternoon, SHRMLI Long Island. This is Henry Shapiro. Thank you everybody that is dialed in for what looks to be a beautiful Friday afternoon. I hope everybody enjoyed their Memorial Day weekend, has great summer plans coming up. Looks like the weather is going to cooperate. I hear tomorrow is going to be nice, maybe some rain on Sunday, but at least it's better than snow and cold and ice. So today we are going to talk about what's been going on a little bit south of us, down in D.C., what's relevant at the Supreme Court. We're going to talk a little bit about two main topics: class arbitrations, which I'm sure some of the people on this phone have arbitration agreements with their employees, some do not. There's pros, there's cons. We'll go into that quickly. We're going to move pretty fast because there's a lot of information today. And we're also going to talk about a recurring theme at the Supreme Court, which is sexual orientation discrimination. It's just to put this out up front, is something that's already protected in New York State. It's protected in New York City. An employer cannot discriminate on the basis of an employee's sexual orientation. It has been for, I want to say, at least 30 years at this point, if my math serves me correct, debated for quite some time at the Supreme Court as to whether sexual orientation is covered under Title VII of the Civil Rights Act of 1964. Currently, it is not. There is a current circuit split, which means out of the circuit courts across the country, we have differing judicial opinions as to whether or not sexual orientation is protected under Title VII, whether it's covered by Title VII. Usually the carve-out is courts will find that it is an extension of the term sex, which is protected under Title VII, and they have trouble differentiating between sexual orientation versus sex. So we will get into a couple of recent cases, and including one that took place right here in the Second Circuit called Zarda, that some of you might have heard of, because it involved a skydiving facility out here on Long Island. So near and dear to our hearts. That case is going to be heard by the Supreme Court, and we will likely get some level of clarity as to whether sexual orientation will be included in the protections for employees of Title VII if anybody were a betting man or woman. You would think with the current constituency on the Supreme Court, with the recent appointments by President Trump of Justice Kavanaugh, and we also have Justice Gorsuch, so some newer conservative justices, that it is likely that we will not get more employee-friendly protections, but who knows. So let's move forward into class arbitration. So there was a series of cases that hit the Supreme Court last year. We're at the one-year anniversary of it. Epic Systems is what it is commonly referred to as. Obviously, it provides certainty because it clears up what was a circuit split, and the nutshell version of this split was class action waivers in arbitration agreements. Basically, were they enforceable or were they not? It's a way for an employer to prevent against what could be very costly class actions. For anybody that's ever faced one or litigated or even settled one, you will know that the more plaintiffs that are added, and there's some attorneys out there who do these regularly on the plaintiff side, the more individuals that are added, obviously the more expensive the claims can become and the more costly it is for you as an employer to litigate. So the National Labor Relations Board, which enforces the National Labor Relations Act, for quite some time had several decisions and opinions that class action waivers in arbitration agreements were unlawful. Why? Because they prevented employees from basically acting in concert, from engaging in concerted activity, which just means more than one employee, to file a class action arbitration or a class action lawsuit. That these waivers saying that you cannot bring a class action under an arbitration agreement were unlawful. They stomped on employees' rights, essentially. There were circuit court decisions that went the other way, that said that these are lawful and they are enforceable, and that a class action waiver in an arbitration agreement is valid. So we ended up similar to what I was speaking about with the sexual orientation protection under Title VII. We ended up with a circuit split, which led us to the Epic Systems line of cases. So what did the Supreme Court ultimately hold? That an employer can require employees to agree to resolve disputes in arbitration and can include a waiver of the right to participate in a class or collective action in the agreement. So that's big. It's a big win for employers. It's not entirely surprising. It goes against what the NLRB wanted, which is the National Labor Relations Board, which is historically known for protecting employees' rights, especially under the President Obama board. It is slowly changing over to a President Trump Republican board as he has appointed Republican members. There's now a 3-2 Republican-favored split at the Labor Board, which will also justify why certain Labor Board cases are changing back over to more of an employer-friendly approach, and certain employee-friendly law that came out over about the last decade is now, even a little bit more, is now becoming a thing of the past and becoming old law. But this is a flip-flop that we can expect to see if the presidency changes hands in 2020 to a Democratic candidate. If it remains President Trump or any Republican candidate in 2020 through 2024, we will likely get more of the trend we are seeing. So Supreme Court ultimately rejected the argument that class action waivers violate employees' rights to act collectively, which was the National Labor Relations Board point, as well as certain circuit courts' point. So, as we said, handed employers a victory in attempting to prevent class action through contractual arbitration agreements. That's why employers generally have these class action waivers, is to avoid the costliness of litigating a class action lawsuit or a class action arbitration, which we'll go into in a minute about why arbitration agreements could work for you, why they also might be something you don't want to consider. But being able to force these to come on an individual basis is a win for employers that took several years to get to. So now courts normally skeptical of contractual arbitration. The Ninth Circuit Court of Appeals, which covers California, as many of you I am sure know, that is a very employee-friendly court of appeals, employee-friendly state in California. Not far off from New York, but it by far leads the nation in employee-friendly determinations. They have followed, but even them, they have followed Epic Systems to certify representative actions. So Epic Systems, Supreme Court law becomes the law of the land. Circuit courts are not generally going to go against the Supreme Court without running the risk of being overruled. Again, shows the importance of properly drafted arbitration agreements. You want to make sure you have that class action waiver in there now that it's lawful. There's going to be a new case we're going to get to in a second, which is right here, LAMPS Plus, that speaks to why it's important to draft tightly and correctly, and the ultimate risk that you could face if you don't. LAMPS Plus, the Supreme Court essentially bailed employers out and bailed out drafters when they were not specific and articulate in drafting the arbitration agreement. But this was a lifeline that I can't sit here and tell you was entirely expected, because historically, under the law, when there's an ambiguity in an arbitration agreement, or in any agreement, I should say, when there's an ambiguity in a document or a contract, anything drafted, it's usually construed, typically, against the individual or the entity drafting it. So with an arbitration agreement, that will be the employer. The employee is not drafting his or her own arbitration agreement. So if there is something ambiguous or unclear, it is usually construed against the drafter, which would mean against the employer. This case actually helps the employer. So class action arbitration is such a departure from ordinary bilateral arbitration of individual disputes that courts may compel class action arbitration only where the parties expressly declare their intention to be bound by such actions in the arbitration agreement. So that's big. It has to be expressly declared. Courts may not, if you look at that quote, courts may not, and this is the big piece you take away from LAMPS Plus, Courts may not infer from an ambiguous agreement that parties have consented to arbitrate on a class-wide basis. So in this case, the arbitration agreement was unclear. The individual tried bringing a class action suit under the arbitration agreement, and he made it through the Ninth Circuit, which I said was very employee-friendly, made it through the district court, made it through the Ninth Circuit. They said he's allowed to bring it, and then get to the Supreme Court. What happens? They say, no, ambiguity. Again, a conservative, Republican, now Trump-heavy Supreme Court at this point. Supreme Court says just because it is unclear doesn't mean that they intended to allow class action arbitration. So even though it was unclear whether or not they would agree to it, this case makes it very clear that it must be expressly stated. So again, careful drafting is very important when it comes to putting together an arbitration agreement. I would always advise, if you work with Jackson Lewis or whatever counsel you work with, don't pull these together on your own. Have somebody take a look at it. So be careful what you wish for. What are the advantages of arbitration? Very quickly, you don't run the risk of a runaway jury, so a jury that you really don't have control on. Also, there's a benefit to jury waivers, as I'm sure you've been told many times, until someone's blue in the face. This is a controlled environment with a single arbitrator. You have greater privacy. This is not something that's going to be on a federal docket, not something that's probably going to be covered by the media. So there's an advantage to going through arbitration from a privacy standpoint. Shorter times of resolution. The court dockets are incredibly jammed up, state and federal. Things don't move super quickly. You get a date, you go to arbitrate, and you will hopefully get a determination within a year, maybe even within a couple of months, maybe even shorter than that. Ability to tailor discovery rules. You and the opposing side will obviously have the ability to work with the arbitrator to determine what is relevant, what should come up. It's less regimented than the court system. Disadvantages: obviously, the more individual arbitrations you get, you have to pay for an arbitrator each time. You have to use your time and your resources to get there and get through it. It's expensive, especially because there's no class. Employees start bringing these individually. You obviously run the risk of coordinated individual action, so getting the same action over and over again. But if you get a favorable determination, that will obviously help you moving forward, because you can rely on, especially if you're before the same arbitrator, you can rely on what that arbitrator has said in the past. It's not necessarily that it's binding, but it's certain to be influential. It's difficult to obtain summary judgment. Obviously, that's something that we look for in the court system. We try to get summary judgment before we get to a trial if there's no genuine issue of material fact. Arbitrators tend to split the difference, which is one of the bigger knocks on arbitrators. They will try to sometimes either split the difference or split the baby, find a way to make everybody a little bit happy and a little bit unhappy, so to speak, compromise. No right to appeal. The arbitrator's decision is binding, it's final. It's very hard to vacate an arbitrator's award. Getting into why you would want to do it, obviously if you get an unfavorable award, it's easier to appeal it if you're at the district court level to an appellate court rather than appealing an arbitrator's decision. So sexual orientation discrimination, while I'm up against the clock, the Zarda case that I brought up at the start of this, there was a gay skydiving instructor discloses a sexual orientation to a female customer's boyfriend, calls Altitude Express, the employer, to complain about Zarda being gay. And this is, again, out here on Long Island. As a result, Altitude Express terminates the employee. He files a lawsuit claiming, you terminated me unlawfully, you discriminated against me based on my sexual orientation, and that is covered by Title VII. It is part of my sex. So, originally, back in 2017, Second Circuit, which is the Circuit Court of Appeals for New York, Vermont, Connecticut, covers, obviously, the state that we are all in, affirms the United States Eastern District, saying, yep, case law states, Supreme Court states, Title VII doesn't protect sexual orientation discrimination. It's not part of the law. So Zarda's counsel moves to get an en banc review, which means instead of hearing from only a select panel of judges, usually 3 judges, 4 judges, you get the entire panel, all the Second Circuit judges, listen to the argument. That happens. He gets that, which is not easy to get. He gets that, orally argues his case. February 26, 2018, we get a decision. Second Circuit, our circuit court, says Title VII prohibits discrimination based on an individual's sexual orientation. Landmark, big, monumental, something that wasn't previously covered. Going a little bit behind their reasoning. And remember, this is not the law of the land yet. This is the law in New York, according to the Second Circuit. But again, putting the federal law to the side for a minute, New York State, New York City, they do protect sexual orientation discrimination. It cannot happen under the state human rights law. So why did the Second Circuit somewhat change the tide and say that this sexual orientation is protected? It's a subset of sex discrimination, which is kind of what I was alluding to earlier. It is very hard, the court feels, to distinguish the difference between sex and sexual orientation. Because if sexual orientation is defined by one's sex in relation to the sex of those whom one is attracted, making it impossible for an employer to discriminate on the basis of sexual orientation without taking sex into account. So that's just a fancier way of saying your sexual orientation deals with who you like and who you are attracted to, and it's all got a nexus to what your sex is. And that's an argument that's been relied on in the past. Sexual orientation is also based on assumptions or stereotypes about how members of a particular gender should be. Men are supposed to like women, women are supposed to like men. Those are stereotypes. So it's related to a stereotype about your sex. Sex stereotyping is unlawful. Finally, sexual orientation, discrimination is associational discrimination, because an adverse employment action motivated by the employer's opposition to association between members of particular sexes discriminates against an employee on the basis of sex. So, somewhat more of the same. Each of these perspectives is sufficient to support the court's conclusion. Together, they amply demonstrate sexual orientation discrimination is a form of sex discrimination. The big part is this last one. May Altitude Express files a petition for review with the Supreme Court. Granted, the Supreme Court will hear this case. A little bit of history. Why are they hearing this case? Because we have a circuit split. So we have the Seventh, which is what I alluded to in the beginning. We had a teacher in the Seventh Circuit. This is started out in Indiana. Seventh Circuit. She filed a claim with the Equal Employment Opportunity Commission. She was passed over for as a teacher for promotions. She was a part-time teacher. Did not get an offer of a full-time position, despite people that were hired after her getting a full-time position. Then eventually in 2014, I believe it was, her, or 2011 or 2014, her part-time status is actually terminated, and she is no longer a teacher for Ivy Tech Community College. She had claimed she was blocked from full-time employment without just cause. Seventh Circuit holds sexual orientation is protected under Title VII. So they fall in line with the Second Circuit, although this came first. Then we have an 11th Circuit case, and this is where the split comes in. In sum, on this slide, the 11th Circuit found that sexual orientation is not protected under Title VII, hence a circuit split. So, where do we go from here? We have the Supreme Court going to hear this ARDA case. Again, gambling would not expect them to loop in sexual orientation to the protections, but that's just my opinion and my guess. I think you will see Justices Ruth Bader Ginsburg, Justice Kagan, the more liberal judges on the court fall in the favor of a dissenting opinion, probably stating that it should be covered. But we have a Republican majority, conservative thinking justices on the court, so we will see. Right now, Congress, outside of the Supreme Court, so we have the legislature, Congress, considering a bill that would codify protections based on lesbian, gay, bisexual, and transgender status. It would provide broader protections than what the Supreme Court is actually reviewing right now, which is just a sexual orientation piece. Legislation in Congress would expressly include sexual orientation and gender identity in the definition of sex under the federal anti-discrimination laws. So it would somewhat short-circuit what the Supreme Court is doing if that were to happen, but we're not there yet. Just on the state side, again, you all know what you are covered under with New York. Several states already included. You see top gender. This is a little bit of an older piece, gender identity and or gender expression. Then others explicitly prohibit sexual orientation discrimination, which is the bottom. You'll see New York in there. But New York has changed with the gender identity and or gender expression. 2015, we have Governor Cuomo issuing statewide regulations. Then we move over to something that I actually spoke to all of you about 3 months ago or so. The Gender Expression Non-Discrimination Act prohibits discrimination based on gender identity and expression under the state human rights law. So sexual orientation, gender identity, gender expression, transgender status, this is all now going to be protected under New York. A citizens movement towards expanding the workplace protections in the area of sexual orientation and gender identity. So what do we do from here? We stay proactive. We are not reactive. That's always your best advice. Stay tuned for changes. Obviously, keep coming to, if you come to the breakfast series, if you have questions, call your counsel, stay on top of things, tune into these webinars, go to the monthly dinner meetings, consider arbitration agreements. We went over some of the pros and cons earlier, but consider if they are right for your workforce. It's something that it's a decision that I recommend you make with the advice of counsel to see what's right for you. Always, and it's kind of your generic ones, always maintain updated handbooks and policies. There's always new laws. We have the city lactation law if you're in the city. We obviously have the newer sexual harassment protections, and enforce your company policies equally. That's something you will always want to do, is be consistent. Don't play favorites. Make sure that you are applying policies equally to the 1-year employee versus the 30-year employee, and across all the different protected categories, everyone treated the same. So be consistent. And for everybody that tuned in and stayed with me the extra 2 minutes, I thank you. Have a wonderful weekend. And next time I talk to you, we will officially be in the summer. So enjoy the final month of spring. Take care, everyone.